The goals of the United Nations. 1. To maintain international peace and security. 2. To take effective collective measures for the prevention and removal of threats to the peace, and for the suppression of acts of aggression or other breaches of the peace. 3. To bring about by peaceful means, and in conformity with the principles of justice and international law, adjustment or settlement of international disputes or situations which might lead to a breach of the peace. The diplomatic and judicial ways are the two ways that a dispute can be solved. Diplomatic negotiation is seen as the most satisfactory method of settlement, as the parties freely express their opinions about the dispute during the negotiations. Diplomatic negotiation differs from the method of consultation in purpose. Consultation is the taking of the opinion of the other side of the dispute. Negotiation, on the other hand, aims to reach a definitive conclusion about the dispute in the agreement of the parties. The name of the method used when a third party, usually a country or an international organization, helps to solve the dispute by only transmitting messages is good offices. In the good offices method, the third party is not welcome to make recommendations but just convey the messages. In mediation method, however, the mediator is expected to make recommendations as well. In arbitration, upon the application of the parties, the Permanent Court of Arbitration will decide on the dispute and the parties must comply with it. However, decision-making in mediation lies within the parties. In arbitration, one party loses while the other wins. However, since the parties reach an agreement in mediation, a win-win result occurs for both parties. Arbitration focuses more on the merits and legal aspects of the case. Nevertheless, a political effect is also added to the conflict in mediation. Diplomatic method used in the Annan Plan is mediation. The main objectives of the conciliation method are to determine disputes, to reduce tension, to encourage the negotiations of the parties, and to establish communication between the parties. The conciliation method is more objective than the mediation method, because it is far from political effects. The purposes of the investigation method. Obtaining the necessary data to make a decision about dispute by international organizations. Determining whether the parties comply with an agreement between the parties. Reaching concrete information to find a solution about the dispute. The Hague Convention for the Pacific Settlement of International Disputes was established in 1899. A state which is not party to the Hague Convention cannot apply for arbitration, but they can apply for information and requests. The Permanent Court of Arbitration has three bodies: the members of the court, the International Bureau, the Administrative Council. The International Court of Justice has two types of powers, namely binding decision-making and consultation in interstate cases. Some examples of the advisory opinions of the International Court of Justice. Advisory opinions on whether the World Health Organization is authorized to apply to the court on the legality of nuclear weapons, as well as the advisory opinions on whether nuclear weapons, the wall built by Israel, and the Declaration of Independence of Kosovo are in compliance with the law. The Court of Justice of the European Union is the judicial authority of the EU. The headquarters of the Court of Justice of the European Union is in Luxembourg. The purpose is to ensure the interpretation and application of European Union law. For this purpose, the Court of Justice of the European Union reviews whether the actions of the European Union institutions comply with the law, ensures that the member states of the Union comply with the obligations under the treaties, and interprets European Union law at the request of the national courts. It consists of two structures, the Court of Justice and the General Court, established in 1988. The World Trade Organization, WTO, which has the main objectives of facilitating the circulation of goods and services in international trade and of making the legislation related to investment predictable, and whose founders include Turkey, officially started its activities on January 1, 1995. Turkey has been a founding member of the WTO since March 26, 1995 by the decision of the Council of Ministers. One of the most important features of the WTO is that it has a dispute settlement body whose secretariat is located in Geneva, enabling WTO members to take trade disputes to the DSB if they cannot resolve them through bilateral negotiations. In dispute resolution within the World Trade Organization, judicial or peaceful dispute resolution methods can be used. These solutions include mediation, conciliation, negotiation, arbitration, panel, and appeal judgment. The methods of peaceful settlement disputes. Good offices. Diplomatic negotiation. Conciliation. The Court of Justice consists of 27 judges and 11 advocate generals. The Court of Justice earlier had 28 judges. With the separation of the United Kingdom from the EU on January 31, 2020, the number of judges in the court decreased to 27. Judges and advocate generals are appointed for a renewable 6-year term with joint agreement of the governments of the member states. The non-judicial peaceful settlement methods. Conciliation. Good offices. Mediation. Negotiation. Investigation. Mediation refers to the participation of an international organization, a third state or one person in negotiations with the states that are parties to a dispute in order to resolve their disputes. In international law, negotiation is also carried out as diplomatic negotiation, and this method is one of the most frequently used settlement methods. A diplomatic negotiation is the discussion or examination of a dispute, a matter, an agreement to be made, or an attempt to take place, between two or more parties, verbally or in writing. Negotiations usually take place only with the participation of the parties. But with the approval of the parties, third parties may also join the meeting. Multilateral negotiations usually take place under the name of conference or congress. If there is no agreement or an acceptable tradition regarding the resolution of disputes between the parties, it is not possible to mention the necessity of reaching a conclusion. In other words, there is no obligation to reach a solution as a result of the meeting. Conciliation. A peaceful settlement method in which the states that are parties to the dispute create an independent commission and ask this commission to examine the issue and bring solutions to them. The International Court of Justice was established due to the need for an independent and impartial tribunal for the resolution of disputes between states after the First World War. As permanent court of international justice, it is one of the main organs of the United Nations that replaced this court with the establishment of the United Nations after the Second World War.